Welcome to Ep.2 of the Real Estate Wholesaling podcast, where we discuss finding, financing, and facilitating off-market real estate deals. I'm your host, Deji Odunton, and I'm joined on the show today by real estate investor lawyer Shawn Quigg to discuss and share his knowledge on the legalities of wholesaling. In today's episode, Shawn and I discuss and answer the age-old question: is wholesaling legal? We also discuss real estate wholesaling end to end from a legal perspective. We discuss if it's legal to wholesale or not. We also touch on the laws that govern wholesaling in Canada, the differences between wholesalers and realtors from a legal perspective. And then finally, we get into the weeds of it by discussing things about contracts, clauses, disclosures that wholesalers need to know about to stay on the right side of the law. So you definitely don't want to miss this. So be sure to listen to the end. And now, before we dive in, I want to say a big thank you to everyone who is tuning in. If you're a fan of this podcast, hit the like, subscribe, and notification buttons. A 5-star rating and review would also be greatly appreciated. So now let's dive into this episode. Hi, Shawn. Welcome to the Real Estate Wholesaling podcast.
Deji, thank you so much for having me.
Thank you very much for being here, Shawn. This is a very, very surreal moment because I recall probably like a year and a half ago, I called you and I remember one of the things I said, I was like, hey, I need help with writing a contract. And I said, forgive me because, this is my first time doing this. I don't know what I'm doing. And you said, oh, no, it's fine. And since then, I know we've done a lot of deals. It's been over a year. So it's really surreal that you are here today. So thank you very much for coming on.
Well, it's my pleasure. And I remember that phone call. When I obviously I don't use your name, but when I mention the success of my clients, I often mention your story because your trajectory has exponentially turned upwards.
Thank you.
Going from that very first deal to where you are now, and it's been awesome to be a part of it, to watch it grow and do really cool things. So, and I'm so happy to be here as a guest on your show.
Thanks, Shawn. And the reason why we're having this podcast is to be able to share that experience with everyone else. And I think a lot of the conversations that we've had over the past year, I know there was another one that when you told me about the new process for disposition, I remember saying, hey, Shawn, we need to get on a webinar because I think a lot of people need to know this. So there's a lot of things that we can speak about on this show that's going to be very, very helpful to our listeners. So thank you. So I shouldn't be asking you, to tell me about yourself because I know you and we've been speaking. But for our listeners, do you maybe want to give a quick background of who you are?
Sure. So I am first and foremost a real estate investor. I also happen to be a lawyer who works with real estate investors. And that's because I got a chance to pair my profession and my passion. When I went to law school, I bought a house and I rented out the rooms to other students. I didn't even realize I was house hacking. I didn't realize this was a tremendous wealth building strategy, but it didn't take me long to figure it out. And my real estate journey has grown from there, right into another student rental, into some multifamily, into some pre-construction, flips now, and
In this market?
I'm flipping in this market.
Okay.
And so, yeah, hey, listen, like my view is now is a great time to buy because there's no one else buying. So,
Okay.
um, so my journey has been interesting. It's been cool to be able to take, the business that I like to be involved with personally and integrate it with my profession, be able to have conversations like these with people like you doing cool things and, chip in where I can, help out on the legal side, and really help to create value and grow people's businesses. I get a lot of fulfillment and enjoyment out of that. And of course, working with you has been no exception.
Perfect. I have a quick question. So that first deal you bought in law school, was it an off-market deal?
No, this was before I
Whoa.
realized that there was an off market, right? No, it was an
Okay.
MLS deal. It was in Windsor back in 2015. when you could get a 5-bedroom house pretty close to the university for less than $150,000.
Ooh, okay. But
Yeah, I should have kept it.
so that's a perfect segue to our first question. From your standpoint, from a legal point of view, how would you describe real estate wholesaling?
Great question. Wholesaling is really just the creation of value for multiple parties, right? First of all, we have the seller. Uh, Sellers don't always want to go to market. They don't always want to deal with real estate agents. And there's nothing against real estate agents, but they're not for everybody. And so what a wholesaler does is they make an offer off market, meaning not listed on the multiple listing service, to a seller, an owner of real estate. And if that offer is attractive enough to that seller, then that seller enters into that deal. Now we have a binding agreement between the wholesaler, who is presently at this time the buyer, and the seller for the house for a certain amount of money, consideration flowing back. That wholesaler then takes that contract, which is itself an asset, and sells the contract for a fee. Right? So we're not selling real estate, and we'll get into this in depth later on, but we're selling a contract. And
Okay.
we create value in this sense as well. There's an investor who wants to do a project. Maybe it's a flip, maybe it's a duplex conversion, maybe we're wholesaling a small multifamily, so maybe it's a BRRRR or just a traditional buy and hold. And so we're helping the seller get what they want, which is out of the property, maybe pay off that mortgage and be free of that stress. We have some value creation for the buyer. They're getting typically a good deal, something that they want at a price point that works for them. And of course, they're going to pay the wholesaler a fee for that asset, that contract. And so there's value creation for the wholesaler as well.
Okay. Well, that's a lot to unpack. You had mentioned that a seller can choose not to sell with a real estate agent. So, a quick question: do you need a license as a wholesaler to basically go through the process that you just walked us through?
No, because you're not trading real estate. There's an important distinction here, and I'm glad you asked this question. Trading in real estate is the activity of representing buyers or sellers in their purchase or sale
Okay.
of real estate. But a wholesaler is not trading. They're actually the buyer or the seller at the given point in time. And remember what I said earlier. They are not selling the house, right?
Okay.
That would require
A
a real
license.
estate agent license, right? With RICO. They are selling the contract.
Okay.
And this is a very important distinction. No one needs a license to sell a contract. And when I say sell a contract, I mean assign the rights and obligations of that contract to another entity, be it a person or a corporation, right?
So, what's
But
that called? The process of assigning your rights in a contract.
well, I mean, it's simply called an assignment, but what you're assigning is an equitable interest, right?
Okay.
So when you lock up a property in an agreement of purchase and sale, whether it's on something that looks like an OREA form or other form in other provinces, or whether it's on a single sheet of paper or whatever it might be, if we have a valid contract, and we'll get into the three components of a valid contract in a second,
Okay.
you can sell, any individual in this province, being the province of Ontario, can sell that contract without a license. And
Okay.
this is a very important distinction for wholesalers or aspiring wholesalers, because you're going to have people tell you, this is illegal, this requires a license. It's simply not. And that's because of this distinction that you're only selling a piece of paper, not a property.
Okay. So, when people say wholesalers are not licensed like realtors and they are selling assignments, as you say, or their equitable interest in the contract, does it make that process illegal?
Absolutely not. There's nothing illegal about assigning rights and obligations under a contract. In fact, In other industries, it's very commonplace. In the business buying and selling industry, it's very commonplace.
Okay.
In manufacturing, it's commonplace. Accounts receivable factoring, which is another industry where a company sells its accounts receivable for maybe 85 cents on the dollar because they need cash now, and they sell those accounts receivable to another company who has the time and interest to make that little bit of spread and wait for that cash flow to come in. So assigning is a natural component of contract law. It's taught in law school. It's
Okay.
completely lawful. It's just that because it's so closely connected to a regulated portion of the industry, often people conflate the two concepts when in fact they are quite distinct.
Oh, that's very interesting. Okay. So if someone wanted to do further research, are there laws that I would say guide the
Well,
trading of real estate
certainly,
in
each
Canada?
province is going to have its own legislation with respect to the regulation of real estate agents. And that's really the legislation that matters here, right? So the trading of real estate is a matter that under the Constitution falls to the jurisdiction of the province. So each province is going to have its own piece of legislation. And I can't really speak to the other provinces, but in Ontario, we have legislation that defines how realtors are to act and conduct themselves, how they're going to be licensed, who
Okay.
the licensing body is, etc. But this law isn't all that relevant for wholesalers because they're not trading in real estate. They're trading in contracts. They're not at all governed by the Real Estate Council of Ontario, and anyone who suggests otherwise is simply mistaken.
Okay. So if the end all be all for wholesalers would be this contract that you speak of, are there any clauses within the contract that you would say allow a wholesaler to assign his or her rights in that contract? What
Well,
needs to be in that contract?
technically, nothing. All contracts are assignable by right, absent a prohibition. So we often
Okay.
see this in new build deals, right? New build construction deals usually have a
Okay.
clause which prohibits assignment. That that is the only thing that
Okay.
cannot be present for a wholesaler to be able to assign. And I don't know that the market is really catching up with wholesalers such that that's something that they need to be concerned about. Nor do I think that general buyers and sellers of real estate are going to be sophisticated enough to consider asking for that term. And of course, if they did, there just wouldn't be a deal because the wholesaler wouldn't be able to assign that contract, and that would be that. But to make things easy and less complicated, it's preferable to have an assignment clause in the Schedule A
Okay.
of the agreement of purchase and sale, presuming that you are using something similar to the Ontario Real Estate Association's form of contract. And there are a couple important components of this
Okay.
clause. Number one, it should be operative to the point when notice is provided. So what I mean by that is as soon as the assignment agreement is entered into, the clause should set out that upon the seller receiving notice of the assignment and the
Okay.
assignee's covenant to perform the obligations of the buyer, that's what makes the assignment work. That is critical. And
Okay.
typical assignment clauses are written in this manner. The second part of that clause that is important is that we want to have the buyer be released of liability upon the assignment, right? So it is
Okay.
important that this is in there because if it is not and the assignee doesn't close, then you as the wholesaler might become liable, even though you had no say and had no participation in the attempt to actually close.
Okay. So if I understand you correctly and I can play this back, the concept of wholesaling is assigning your rights and your interests. You're also assigning your
In a sense,
liabilities as
yes.
well,
Your
if I get you
liability
correctly.
is more like transferring because you're no longer in the deal as the assignor, right? So this is another important concept, and I see a lot of
Okay.
wholesalers not quite get this right. And so it's important to understand that in contract law, we look at a legal concept called privity of contract. And what privity says is that only the parties that are a party to a contract can sue each other with respect to that contract. So think of it like a chain link fence,
Okay.
right? So, Deji, if you're a seller of real estate and I'm a buyer, and you and I enter into an agreement of purchase and sale, we now have a chain link between us, right? There's a connection, it's that contract. Now, let's say I go to someone over here and I say, hey, I've got this contract, I want to sell it to you. And they say, great. Okay, they agree to the fee, they agree to the terms, etc. Right? So I do an assignment agreement with this individual. As soon as that happens, the chain between you and I, Deji, is broken. In fact, it's gone. And that chain is replaced by a chain between you and the assignee. There's another chain, and it's between me and the assignee, but
Okay.
now neither you nor I can sue each other with respect to this transaction, unless the Schedule A term left me on the hook. Does that make sense?
It does. Let me try to play this back. So if I have a deal under contract with a seller, the moment I assign that deal to a private buyer, I immediately leave the deal.
As
So I
between
am no
you,
more
that's right, as
privy
between
to
you and
that
the
deal.
seller.
So that deal becomes okay. So now
That's right.
that deal is now between the seller and the buyer. Okay. So now in those scenarios, once you have assigned your rights, your liabilities to a buyer,
From
contractually,
whose
what are
perspective?
you able to do
Nothing.
from
You
the
have
wholesaler?
no standing, what we would call standing, in the original agreement of purchase and sale. Any changes to the agreement of purchase and sale has to be negotiated between the seller and the assignee. Now, that doesn't mean you can't step in and assist, right? You've
Okay.
created a relationship with the seller, presumably. You've got a relationship with the assignee, right? You might be able to step in and assist. If they come to a deal and you need to paper it and put it through DocuSign, great. But ultimately, you'll probably want to back away and let each of their respective lawyers assist them with any sort of negotiation or change in terms. Mm-hmm.
Okay. So I have a quick question. In an event when, for example, a wholesaler gets a property under contract at a set price and assigns that to a private buyer at another price.
Okay.
So let's say the fee is $10,000, for instance. And now you say that I'm no more part of the deal. So if there's an issue with closing, is there anything I'm able to do contractually to guarantee my fee for that deal, even if I'm not part of that
Yes.
deal contractually anymore?
And that's because you do have a deal with the assignee. So the terms of your assignment agreement should make the deposit non-refundable under any circumstances, and also include a particular
Okay.
clause that says that unless the seller is the one who refuses to close, the buyer has, in essence, earned the service, or rather the assignor has earned the fee, and it becomes due and payable. Now, this is a complex type of clause called a liquidated damages clause. And you need, if you're a wholesaler out there and you're listening to this, you need to speak to your lawyer about drafting up a liquidated damages clause. That's because the courts don't like them all that much. And so they have to meet certain criteria and be precise, because if they're not, it'll get tossed if you have to sue, right? So in this case, a $10,000 fee, you could go to small claims court, claim breach of contract, and hopefully get a settlement or get your fee. But it may not even be worth it, right? Once you get into the larger wholesale fees, things sort of change, right? Now we want to make sure we're absolutely dialed in, because if we're not, and there's some issue with closing, we want to be able to sue for your fee, because you've done the work, right? You've done the work, you've done a deal with someone, now they got to pay. And if they try not to, then we need to be able to successfully sue them.
Okay, so playing this back, a wholesaler has a contract, an initial contract with the seller at the onset of a deal,
Yeah,
and that's a binding contract between those parties. Now, once that deal is under contract, there are clauses that you mentioned, like the assignment clause, that help to assign the rights to someone else. Now, once that contract is assigned, the wholesaler leaves the deal, now has
that's right.
another contract with the buyer. Okay. Cool. So there's two
That's
sets
right.
of contracts that we're discussing here. Okay. So can you maybe touch on what those two contracts are? And are there any other contracts that a wholesaler would
in
need
essence, to
to
answer your
essentially
second
get a deal
question,
done?
there are no other contracts required, absent extenuating circumstances. There's a very little known strategy that is used more so in the US called novation, which is similar to wholesaling. It's probably outside of scope for
Okay.
today's conversation. Perhaps we could have another one. But that might require an additional contract. But for your bread and butter
Okay.
wholesaling, you only need two deals, right? The agreement of purchase and sale, and the assignment contract. And that's really it. They don't even have to be all that robust, right? As long as they form a valid contract. And I mentioned earlier that I would discuss what a valid contract is. And so I'll do so now. A valid contract really requires only three things, with a fourth thrown in if it's in real estate. Right? The first component of a contract is an offer.
Okay.
Right? So, Deji, you have a house. I give you an offer of $200,000 for that house, right? I've made an offer. I've shown my intent to purchase something from you for $200,000. The second component of a contract required for a contract to be valid is acceptance. You got to look at what I've presented to you, and you got to go, yeah, okay. And there's got to be some evidence of acceptance. The traditional way of showing acceptance is a signature. And when it comes to the Ontario Real Estate Association form, a confirmation of acceptance, which, if you're taking a look at the signature page, is just below the signatures. The third component of a contract required in all contracts in this country is consideration. Something has to flow both ways. So in the case of our fictitious deal, I'm giving you $200,000 and you're giving me title to a property, right? So we have consideration flowing both ways. The last component that's relevant to Ontario real estate deals is that it has to be in writing. Now, that's not the case for all contracts, but real estate contracts, it is the case. And so my offer's got to be in writing. It's got to be signed by me. That shows I have intent. You have to sign where it says accept. Right now we have acceptance. The deal can't be for $0. It has to be for at least $1. And it can, because the courts, maybe you've heard of the peppercorn theory
Okay.
or the peppercorn case, but there's a long-standing case that had to do with a contract where someone performed a service in exchange for something of little value, and the court said, doesn't matter if it's in exchange for a peppercorn, the court's not going to determine what is sufficient value. That's up to free contracting parties. So it doesn't matter what value is, it just has to be
Got
some
it.
value, right? Once we have those
Okay.
components and it's all in writing, we've got a valid Ontario real estate deal. Which leads me to another point. And this point, even some lawyers get this wrong. A deposit is not what
Okay, let's
makes a
go.
contract valid. No deposit is required for a contract to be valid. Now, that's different than at any stage.
At any stage?
At any
Or,
stage. A
so
deposit is simply
at any
a
stage?
term.
Okay.
Now, the courts have deemed it a fundamental term, but that's a different discussion, right? If the deposit says $0, it is still a valid contract if there is offer, acceptance, consideration in writing. But if it says $100,000 and you only submit 50 or you don't submit any, then we have a breach of a fundamental term of the contract, which gives the seller certain rights that they wouldn't ordinarily get for breach of a regular term. Does that make sense?
Okay. Okay. So just to unpack this, if the agreement between the wholesaler and the seller is for no deposit to be put down, at that point, the contract is still valid. But if the agreement is to put down with deposits and you don't put down the deposits, then there's a breach.
That's exactly right.
Am I capturing that correctly? Okay. And this is quite interesting because I had a call from someone a week and a half, and the person was asking me about deposits. And I mentioned that for some of the deals that I do, I don't put deposits. What I do in some cases is we put the deposits when we are waiving conditions. So in that scenario, if, for example, there's a deal of $100,000 and there is a clause saying this is going to be a tiered deposit clause, for instance, or it says the amount will be put upon waiving conditions, does that make
There's
that contract valid or invalid or
term
illegal
like that. Tiered
when it's done
deposits
that way?
are very common in large transactions. They are common in commercial real estate. Having no deposit is less common because the traditional viewpoint on a deposit is that it gives the seller some confidence that the buyer is going to complete the transaction, because if they don't, the seller gets to keep the deposit. That's the whole reason why deposits came about way hundreds of years ago, when contract law was still in its infancy. And the concept of the deposit has lasted through to today, but that doesn't mean that it's required. Now, it also doesn't mean that wholesalers out there should be trying to do deals with no deposit. You're probably going to do less deals if you insist on no deposit. So it's important to develop language that shows, yes, I'm going to close, and no, I'm not going to put a huge deposit down. And that's because I'm running a business and I can't have all that working capital tied up in one deal. Otherwise, my business would shut down.
Yeah. Yeah. So I agree with that. You make a very good point. I think there's a lot of ways, and it really depends on the deal, how the deposits are structured. On the first page of the APS, if you write that you put the deposit upon acceptance, then I imagine at that point in time, once the deal gets under contract, you are then meant to put the deposit in. And if you don't, there would be a breach. There's also an option that says, as otherwise described in this agreement. And it's that clause that allows me to put some clauses in the Schedule A where I can then decide, is this going to be a tiered deposit structure? How much do I put down now? When do I put those deposits down? I wanted to touch on that, Sean. When you do a tier deposit or you use as otherwise described in this agreement, are there any guiding principles as to what you can put in the
This is a great
Schedule A,
question.
or is it
First of
basically a
all, if
blank
you're an
canvas?
aspiring wholesaler or even an experienced one, you should always be putting as otherwise described in this agreement, because the standard wording of the deposit clause in the Ontario Real Estate Association form presents a big problem for business people who are busy. It says that the deposit is due within 24 hours and it has to be paid in a certain way. Now, I have seen a client get burned on this because they didn't pay the deposit in that particular way. And as a result, there was a fundamental breach of the contract and the seller was entitled to rescission. So my client had a multi-$100,000 wholesale fee walk out the door. Yes. So, as otherwise described, should be the default when we are wholesaling property. And what you're going to do in the Schedule A is build in time and flexibility. So here are a couple of ideas or options that can be put into the Schedule A. Because to answer the second part of your question, it is a blank canvas. As long as the terms are not unconscionable or illegal, and there's nothing illegal about deciding how the deposit gets submitted and to who, then it's allowed. So here are a couple of ideas. Number one, the deposit
Okay.
can be submitted within the deposit must be submitted within X business days to the seller's lawyer. It must be submitted within X days of receipt of banking instructions from the seller's lawyer. So this says that I don't have to put any deposit in until the seller's lawyer gives me their e-transfer instructions or their direct deposit or wire instructions. And then, you might want to build in 2 or 3 business
Right.
days, because this builds in the flexibility. So get the deposit out of your account and put it into the lawyers, however you're allowed to do so under the terms. If there's no restriction or if there's no requirement, then you can do an e-transfer, you can do a bank draft, you can do a direct deposit. Do not do cash. Cash is a big problem for lawyers and the trust account. And so avoid cash, right? Pay the $7 or $8 for the bank draft, because you're going to cause a lot less headache for everybody by doing so, including yourself. Second, you could simply say within 5 business days of completion of this transaction, right? This builds in additional time, and you would typically use this if you were depositing the deposit into your own lawyer's trust account. Now you've got further time and flexibility, and you're not being held to a very tight time constraint that you otherwise would be, right? The standard form of contract says 24 hours, except 16 of those hours are not business hours. So, if you've got to submit a deposit to a lawyer's office, you've only got 8 hours. And if you did the deal at 10:01 a.m., if that deposit's not in the trust account by 10 a.m. the next day, the deal's technically dead. if the seller wants it to be. And you don't want to give the seller that power as a wholesaler.
Okay. So from what I gather, the goal here is to reduce the amount of ammunition that you give the seller should they
Well,
choose to
you
want to
want to
back
write the
out of the
deal
deal.
so that they can't back out of the deal, right? You mentioned earlier, this is a binding contract. It is. It's binding on both parties, right? So you want to avoid terms in the Schedule A which give the seller an out, right? Like a lawyer review. Now, if you've got no concerns with the terms, on its face, it might
Okay.
not be a terrible thing to allow lawyer review. But here's what I've seen happen. I've seen the lawyer come in and say,
Okay.
oh, I'll just buy that deal for you for $10,000 more. I've seen that. I've seen lawyers that don't understand what wholesaling is, that see a
Wow.
$1,000 or a $500 deposit and think that it's fraud. I've been called and yelled at on behalf of my clients. I have been emailed being accused of helping to perpetrate real estate fraud, all of which, of course, is nonsense, because there's nothing fraudulent about this. This is simply a different type of way, a different transaction type that most Ontario and probably most Canadian real estate lawyers are simply just not
Okay.
used to seeing. So you want to avoid giving the seller terms that allow them to get it. Second, you really got to get that deposit clause dialed in. That's one of those sneaky
Okay.
reasons that a seller can get out if you don't comply perfectly. And that's a little known escape clause for the seller. Second, you want to take a look at Section 8 of the Agreement of Purchase and Sale if you're using the
Okay.
standard form OREA contract. Section 8 is the title search date. Okay, when you're wholesaling, there's two things to keep in mind here. You're going to put a title search date, which generally should be 1 to 2 weeks in advance of closing, or better yet, set it at 10 business days or 5 business days prior to closing, not the actual date, so that if the closing date changed, the title search date automatically changes with it.
Okay.
But the second thing you'll fill in there is the use of the property. This is another little known escape hatch for the seller. When you're buying, you want that to be as dialed in as possible. Because, sorry, go ahead. The use?
So where do I get that from? Yeah, the use. If someone wants to put that in there, do I use the Geo Warehouse? Do I use MPAC?
Well,
What would you say is
let's
the most dialed
start
in
with
source
where you get the
of
information.
the legal use of a property that
It
should go
wouldn't be
into
Geo.
an APS?
Geo is a helpful tool, but it's a provincial tool. But the use of the property is municipally defined. So it's actually going to come from the zoning bylaw. But if you're a buyer, right, not a wholesaler, if you're a buyer, you're going to write down the use that the seller tells you is
Okay.
legal. This way, if it's
Zoning
not,
bylaw.
you have an escape clause or leverage to negotiate different terms, like perhaps a lower price. But when you're a wholesaler, you need to keep it a little bit more broad. And that's because in the scenario where the buyer thinks they're getting a deal for a duplex, but it's not zoned for a duplex, now they have an escape clause, and so does the seller. And if you take a look at Section 8 of the Standard Form Contract, which I would encourage all listeners to do, you'll see that if the buyer puts forward a title requisition saying, show us that.
Hi, Sean.
Sorry about that, Deji.
No worries. So we're still live. I think the last thing I heard was around the deposits and more around the escape clauses.
Right.
So we're
We were talking about
discussing,
Section 8.
yes, the different types of escape clauses that wholesalers should be very cognizant of.
Okay.
And you were at section 8. Yeah.
Right. So Section 8 is the title search clause. And it has two things to fill in there. The first is the date. We want to anchor that to the closing date by saying, the requisition or the title search date is 5 or 10 business days prior to closing. That means that if the closing date changes, the requisition date changes with it. The second blank to fill in has to do with the use of the property. And the use of the property, when you're buying, you want to get it dialed in to exactly what the seller tells you is the use of the property, right? If this says it's this legal duplex, put legal duplex. If they say it's a legal 7-unit, put a 7-unit. If you're a buyer, not a wholesaler. Because if it's not, if the due diligence turns out that it is not, then what the buyer can do is use its leverage, right? It now has a breach of the contract, except that the seller doesn't have to agree, right? So the escape clause for the seller in Section 8 of the Standard ORIA form says that if the buyer, which in this case would be the assignee, submits a valid requisition and the seller does not want to deal with it, then they can hand the deposit back and get out of the deal scot-free. So as a wholesaler, we want to fill in that blank as broadly as possible so that we don't allow that escape hatch to be opened by either the buyer or the seller.
Okay. So thank you for all those bombs you dropped around those deposits. So outside of deposits in a contract, are there any other exit clauses or exit avenues that sellers could use or could exploit in a contract? What are the things that we should be looking out for in a standard APS?
Yeah, there is one more big one. And it's little known. In fact, if you don't take the time to read the boilerplate language in the standard Ontario Real Estate Association form, you'll probably miss it. And that's in Section 8. Section 8 is the title search / requisition paragraph. And if you're a new wholesaler or new to real estate, you'll see when you pull that section up that there are two things to fill in. The first is a date. Right, that's the date on which the title search requisition letter has to be sent from the buyer to the seller, basically to their lawyers, right? One lawyer to the other.
Yep.
Right. So as an aside, we want to anchor that to closing by saying, instead of filling in a specific date, we want to say, 5 business days prior to close or 10 business day prior to close for a multifamily. And that way, if closing changes, so does the title search date automatically.
Okay.
The second
What's the importance
blank,
of that date?
What's that?
Why is that date important? What happens if that date is maybe a month instead of 5 days or 3 days?
It can be a month in advance. It's really just, coming from the perspective of a lawyer, you may want to make it a little bit later or closer to closing to give your lawyer that extra time.
Okay.
Right. Or to give the lawyer for who will become the buyers a right amount of time. The second blank to fill in Section 8 is where you can get in trouble, right? This is where we set out the use of the property. Now, you might think you can find the use of the property in the GR warehouse printout, but you actually can't, right? It might tell you what it thinks it is, but GR warehouse is a provincial system that pulls from TerraView, being the electronic system for registering title. It is, but use of a property is governed by municipal bylaw.
Got it.
So what we want to do when we're buyers is we want to look up the zoning, but more importantly, we want to listen to what the seller represents the property to be, right? Like if the seller says this is a legal duplex, write in legal duplex. Because what the rest of that paragraph sets out is that if you show that it's a legal duplex, then great. But if you don't, right, if the due diligence says, this isn't a legal duplex, then the buyer has leverage to go, okay, well, I'm going to need a change of terms, or maybe this isn't a deal for me anymore. But the flip side of this, and this is why this is important for wholesalers, is that if the buyer says this better be a legal duplex on closing, and this says that it's not, the seller can hand the deposit back and be out of the deal. So for wholesalers, you can probably see why this is important. The more narrow we make the use, the more likely it is that it's wrong. Right? It doesn't mean that you'll get it wrong, right? If you're buying a single family home in a single family neighborhood, writing single family residential is probably going to work out. But as a wholesaler, you probably want to limit it to residential or commercial or leave it blank.
Okay.
This way, no one, neither the buyer nor the seller, is able to actually open this escape hatch, which is written out in the rest of the paragraph.
Wow. I think I'll definitely need to unpack that. So let me play this back. So if I'm buying a duplex or the seller tells me it's a duplex, but it's zoned as a single family, if I put duplex on section 8, then do I have the right to sue the seller? Or does the buyer now have the right to sue the seller because it's written as duplex on the contract? Whereas on closing, it was found to be something else.
Well, not quite. So you want to sort of get away from the language of sue because the term actually sets out what happens. It's the
Okay.
equivalent of a mutual release. So let's walk through the scenario. Deji, let's say you're selling a property to me and you tell me
Okay.
this is a legal duplex. And as a result, I'm willing to pay $300,000 for it. All right. If it's a
Okay.
single family, I'm probably only paying $150, maybe $200. Right. But you tell me it's a duplex. I'm going to make more money on it. So I'm going to pay you more for it. Okay.
Correct.
Great. I'm going to write legal duplex in that use blank in section 8, right?
Okay.
So when I have my lawyer run a zoning search and it comes up as a single family home, then I can do a couple of things. I can go to you, Deji, and say, look, here's the proof that this is not a legal duplex, right? I want $100,000 off the purchase price,
Okay.
right? You can do one of two things. You can agree, or you can read the rest of the paragraph, which says if I submit a valid requisition, which is make this a legal duplex or the price drops, and you don't want to drop the price and you don't want to go convert it to a duplex legally, you can hand me my deposit back and the deal is at an end. So that's the escape hatch. And the more narrow you make the use, the more likely it is that you've got it wrong, right? Naturally, right? There's a lot that fits into the word residential, but only single family homes fit into single family homes,
Got it. Okay.
right?
So,
So
okay. So
you
the
want,
incentive is to make it as broad as possible.
that's right, as a wholesaler. As a buyer, you want it narrow, but as a wholesaler, you want it broad. In fact, you can leave it blank. A lot of real
Okay.
estate agents leave it blank.
What's the implication of leaving it blank? Because I've left it blank in a couple of transactions.
No one has the right to hold anyone else to their representation because there wasn't one.
Okay. Okay.
Right? It doesn't really
Wow.
matter as a wholesaler because you're not closing. But it matters for a buyer, right? For this exact scenario. If the seller represents and warrants this is a duplex, and as a result, you got to pay me $300. Well, as a buyer, you definitely want duplex to be written in there. Now, as a
Yep.
wholesaler, as a value add for your buyers, you may want to write it in there because there may not be a deal if it's not a duplex, right? And if
Okay.
that's part of your business model to conduct business in that manner, then it may be advantageous as a wholesaler to write it narrowly. right?
Okay.
Where, if it's not a legal duplex, this is actually a terrible deal, right? And if that's what you think, and that's the type of business you want to run, then you may want to write it narrow. But generally, you're going to want to write it blank or broad and tell the buyer, the assigner, or assignee rather, to conduct their own due diligence before taking the assignment.
Okay. This is quite interesting. There's another one that I know that you and I have discussed in the past, and I actually lost a deal because of this. And I wanted to get your thoughts on it, which is spousal consent
Aha,
and how
spousal consent.
and how that could potentially create an escape hatch
Okay,
for a seller.
as a wholesaler, it is critical that you get a title search done to figure out who's on title. This is important for a couple of reasons. Number one, we want to have the seller right, but we also want to be armed with the spousal consent requirement. Under the Family Law Act in Ontario, when a spouse, meaning someone, and under the Family Law Act, that means someone who is married, there are different definitions of spouse for different sections of the Act, but for this purpose, it means married. Okay? When a person is married and they live in a house with their spouse, and they're the only one on title, meaning the husband or wife is not on title, and they attempt to sell the property, the Family Law Act says that the spouse must consent. The standard form of agreement has a small section underneath the signature blocks for spousal consent. As a wholesaler, it is critical that when you're having conversations with the seller, ask them if they're married. If they're married and they're not both on title, then the second spouse needs to sign the spousal consent section of the agreement. Otherwise, the transaction will not go through. Or the seller has an escape hatch. It's possible that the spouse consents later, right, and revives the deal. But if someone tells the seller they maybe shouldn't do this deal, like their lawyer,
Then they
then
have
that's an escape hatch. And yes, it has burned you once, and
yeah,
it's burned others.
it was a
But,
very painful burn. Very
yes, it
painful
was.
burn. Learned that the very hard way. Uh, you know, I would say for close to 3 days, I was like a bit down. I was wondering like how did I miss this? How did I not think through this? So context, the I think it was only the wife on title. The husband wasn't on title, but for months we were negotiating with the husband. So there was nothing to have indicated that he wasn't on board. But unfortunately, someone maybe tossed them the marketing, so they saw the the marketing that we put out for the disposition, and then I got the email say, hey, you know, the husband doesn't consent. I'm like, sorry, come again? Yeah, he doesn't consent. I'm like, for the past 3-4 months, we've been speaking with him, say he doesn't consent. And I was like, oh, interesting. Very, very interesting. Okay. Okay. So you mentioned the the you mentioned something about the forms and being the Ontario real estate forms. I wanted to find out, is there any difference between the branded forms and the blank forms? Like, does it in any way affect the authenticity or the validity of the contract?
No, there are only three things that make a contract valid, and a fourth in real estate: offer, acceptance, consideration on paper. It does. The Ontario Real Estate Association has spent a lot of time and money creating the standard form of agreement for their members, and that's become the standard in Ontario, at least, and I'm sure in other provinces. New Brunswick has a standard form. I think Alberta has a standard form as well, and I'm sure a lot of other provinces do. But you can write an agreement on a napkin. As long as there's an offer, an acceptance, and consideration, it's a valid contract. So no, it doesn't matter if it's not branded or branded, although you should keep in mind that if you're using a branded form, you are technically putting yourself at risk of being contacted by the Ontario Real Estate Association for use of their licensable material without a license. And I've had clients be contacted, and we've coached them on what that means for them, how they should conduct business. And I'm not going to advocate that anyone uses any of the forms without a license. Of course, you should get a license to use it. But I often see that people do not.
Hey, a lot to unpack. Thank you very, very much, Sean. Like I'm thinking through everything that we've discussed, and it's really mind blowing how a lot of things that you would think are normal are really, really, really critical to to take into account. So, if there was any doubt from anyone that wholesaling was illegal, I guess we've debunked that thought process.
Yeah.
It's been an age-old question. Whenever anyone gets into wholesaling, even when I was getting into wholesaling, it was the question on everyone's lips. And I want to say thank you for doing justice to that question.
You're welcome.
So before we jump up, do you have any thoughts or any final comments that you'd like to share with us?
Absolutely. So I see a lot of people getting into wholesaling, and I've had a lot of conversations with new wholesalers and experienced wholesalers. And what I want to tell your listeners, Deji, is that wholesaling is a great business, and there's a lot to it, but it must be precise. The contracts have to be very tight. And if you don't know how to make them tight, come find me. I'll show you how to make them tight. There, one of the mistakes wholesalers make frequently is amending the terms of the agreement, the original agreement, after they've assigned the deal in their own name. All right, so I've done a deal. I've assigned it to you, Deji. You say you want a price decrease. I talk to the seller. They agree. Then I do an amendment in my name with the seller. That's not a valid amendment. It has to be in
I
your name
see.
because you're the assignee. You're the buyer. In fact, Section 3 of the assignment agreement says you're stepping into the role as buyer as if you were the original buyer. So I have no contractual link with the seller anymore, which means this amendment is just a piece of paper. It doesn't mean anything.
So if we flip it on its head, and for example, I assign a deal for 10,000, and then the buyer who I assign it to does an amendment with the seller, maybe a price increase or a price decrease, are they still liable to pay me my assignment fee?
That's right. They are. They are.
Okay.
The price change between the buyer and seller post assignment does not impact you for good or for bad. Your
Okay.
10,000 fee is your 10,000 fee. That's because you have a contract that's separate. It's linked, but it's separate from the original agreement of purchase and sale. Here's another common mistake that is going to burn someone sometime. It hasn't quite yet, but it is going to happen. When, typically the agreement of purchase and sale is conditional for a period of time on due diligence or whatever it might be. And that's the period of time that the wholesaler uses to go out and wholesale the deal. What I often see is the assignment agreement gets signed and become firm, and then the wholesaler goes and writes a notice of fulfillment in their own name to the seller. Not valid. And if the buyer doesn't do it, then the deal typically automatically terminates. This is the worst one. And it's been so close a couple of times. As the wholesaler, you have a couple of options. The simple one is to assign the deal, and in the very same DocuSign package, put the notice of fulfillment with the assignee's name as buyer and have the
Okay.
assignee sign it, right? And then pull that out of the PDF, load it back into DocuSign, and send it to the seller for the acknowledgement at the bottom of the form,
Yeah.
right?
That's really important to note, because I know that you and I have had this conversation multiple times, and I've fallen prey to this. And the process that you walked us through is what we do now, where the first DocuSign goes to the buyer and they execute their portion of the agreement, and they go ahead to put the deposits down. So that shows consideration. It shows, the offer and all that. So it's a valid contract at that point. They put down the deposits. Now, before we execute our portion of the contract, we then go ahead to do the notice of fulfillment with the seller, because at that time, our contract with the seller is still valid, as you said, because we
Right.
haven't fully executed our assignment agreement with the buyer. So once
That's
the
the
notice of
other way.
fulfillment is done with the seller, then we execute the final portion of the assignment agreement with the buyer. And at that point, as you said, it's firm. So I found that, we've had to explain to buyers that new process. Well, it's also cleaner. So thanks for the
Yes.
recommendation.
You're welcome.
Okay. Wow. Again, thank you very, very much. And I have one last question
Okay.
before we let you go. Can you tell us what your biggest L in real estate is and what you've learned from it?
Oh, it's happening right now.
Bank of Canada?
No, I had a deal that I bought from a wholesaler in the spring of 2021, year and a half ago, basically.
Okay.
And it was a wholesale deal for me. A
Okay.
waterfront cottage. Not in the best shape, but a waterfront cottage for a ridiculously low price.
Nice.
I thought it was worth at least $100,000 more as is on market. So what I do? Pay the ridiculous wholesale fee, closed on it, put it on the market. Nobody wanted it.
Ooh.
Nobody wanted it because it turns out it was in way worse shape. So here's lesson number one. I didn't actually go see the property. I relied on my coach who didn't quite fully describe the state of the property.
Okay.
Okay. So if you're buying private, you need to either see the property yourself or someone that is intimately linked to your business who is going to help you needs to see the property. I don't know that I would have bought this property had I seen it, but of course I did, right? Lesson number two, I took too long to pivot strategies, right? I dropped the price, then I dropped it again. I should have just started flipping it right away, but I didn't. Then I hung on. Lesson number three, as soon as it's time to pivot, it's already too late to start raising private money. I should have started getting private money ready as soon as I closed, just
Yeah.
in case. Because the renos, turns out, were going to be extensive. It's a waterfront, great, but it's on Lake Erie and it had no break wall, which means it needed a break wall, which is a massive undertaking, both from a permit point of view, from a capital point of view, and from a sheer project point of view. It took me a year and a half to get that break wall built and $100,000. And I had to bring in a 300-ton crane and 240 tons of armor stone and literally crane it over my house with two neighbors who had absolutely no interest in being even the slightest bit helpful in a meaningful way. So lesson number, whatever number we're at, is be better prepared and be ready to go to exit plan B or C quickly. Had I raised private funds early and hired a full contracting business, I would have been Airbnb in this property all last summer, and it would have done tremendously well. Now, because I have spent so much on holding costs, I'm out of capital, and it doesn't make sense to borrow more to get it to Airbnb ready. So now it's for sale. I would be too leveraged if I was to borrow more. So now it's for sale. So this great Airbnb property, which is this close to being done, I'm not even going to be able to keep after what's going to end up being 2 years of work and time and effort. So I made so many mistakes, but I learned a ton, and I will never make some of these mistakes again. And one of the very first things I learned in real estate is that if you try and save pennies, you lose dollars. And I tried to save pennies, and man, did I lose dollars. So it's not all sunshine and rainbows in this industry. And, even people who are good at what they do make mistakes. I made some, and I'm not going to make again. But this is the big one.
Well, thanks for sharing, Shawn. That's going to stick with me. If you try to save pennies, you lose dollars. I'm sorry to hear that. But yeah, as you said, right? You learn a lot from these mistakes.
Way more than I would have made. The lessons are so critical to the building of the rest of the portfolio that I'll take it.
Yeah. Wow. Okay. If you try to save pennies, you lose dollars.
I can't take credit for that. That was my first. My first coach told me that.
Okay, but it's a fantastic quote for today.
All right.
Okay, so that brings us to the end of this episode. Thanks for joining us today, Shawn. Where can people find you if they want to connect with you?
Best way is Facebook. I'm on Facebook frequently. You can find me, Shawn Quigg, or at the REI Lawyer. I generally respond to messages. We'll set up a time to chat if you have questions, or if you need something quick. I'm typically happy to help out to the extent that I can, keeping in mind my ethical obligations. But I'm always happy to chat real estate or real estate investor law. And Deji, thank you so much for having me on. I'm so pumped to have been a guest on your show.
Thank you very much for coming on, Shawn.
You're welcome.
Perfect. Thank you, Shawn. And that's it, folks. We hope the knowledge of how to wholesale legally was beneficial to you. As always, thanks for listening to the Deals Estate Wholesaling podcast. If you enjoyed the show, please rate and review us on Apple, Google, and Spotify. And be sure to hit that subscribe or notification button so that you know when our next episode drops. And until then, remember, a deal a day keeps scarcity at bay. Thank you.